Tom Zannery, is the attorney for the appellant on?
Yeah, that's PM Oshner, and then Timothy Hertz as well. Bill is signing in, so we should be good to go shortly.
Okay, well, according to my watch, it's 7 o'clock, so I'd like to call the February 10th, 2021 zoning board of appeals meeting to order. My name is Ed Stebbins, the chairman. Also present tonight on the panel is Tom Manning, who is the secretary, Scott Rosato, and Doug Smith is an alternate. He will be sitting in tonight for Floyd Kravitz, who is not present. And is Bill Bouncer on?
I don't see him.
Okay, I think he should be joining us shortly. He said this morning he would be on.
I see Mr. Menzer on the screen.
Oh, you do? Okay.
Yep,
Then
Bill's
I'll
here.
Okay, then I'll have Bill sit for Mr. Fitzgerald, who is also not here. So we have a quorum of 5. We're not doing a variance tonight. We're doing an appeal of the zoning official's decision. We'll take this one step at a time. First of all, we'll have the secretary approve the mailings if they're in order. Then we'll do it in order. I'll have to have the appellant present their case, followed by board members who may have questions. And then the zoning officials side of the story, maybe some questions. And then Don Marr, Attorney Herbst is present. So we'll try to go through it that way. I think that's probably the easiest way. And at the conclusion of the public hearing, and the attorneys are all aware that you don't have to add anything. That's the time that you should not speak. And you're welcome to remain on the line and listen to our discussion and decision.
I'm sorry, this is actually Ron Oshner calling me on my phone. Let me see what he has to
Okay,
say.
sure.
To the audio.
Yep.
It says you're connected.
I am
Can you try
connected.
speaking now?
Yes, I'm here.
It shows as if you're talking. You get closer to the microphone and try it.
Yes. How's that?
Excellent.
Can you hear me now?
Absolutely.
Yeah.
Hold on, I can hear you through the phone.
Okay. Can they hear me?
Okay.
I'm gonna put you on hold so I don't get feedback.
Okay.
But don't hang up.
Yep.
Okay. Is everybody here that's going to be here?
Can you hear Mr. Oshner?
Yes, you just did.
Okay, good. I
Okay.
am a bit soft spoken, so if any of you have any problems, just give me a little wave and I'll try to increase volume.
So we're at the point where I'm going to ask the secretary to read the call of the public hearing.
Okay. The ZBA 21-01, 55 Sealy School Drive,
Okay.
Don Marr Residential. Can everybody hear me?
Yes.
Yes.
Okay, Don Marr Residential, applicant Kenneth M. Nash, agent for appellant Ronald F. Oshner, Esquire, appeal of the zoning official's decision of sections 8.2-12B.1, 8.2-12B2, 8.2-12B3, and 8.2 5-12B4 of the zoning regulations for an intended driveway, pin number 1689-1564-1769 E CR zoning district. Okay, for the record, it was a little bit confusing, I have to tell you, because we had some mailings from the 15th of January and duplicate mailings for the 25th of January. But I was able to, after with considerable problems, just trying to sort it out. But I did conclude that all of them required mailings were sent during the required time and in compliance with the zoning regulations. Okay?
Okay, just one piece
And
of housekeeping. I neglected to introduce also Tom Zanrini, who is the CEO and the planner of the town. He's also present this evening. Okay, Tom, I'm sorry.
okay, before we go ahead, there's a couple of questions that I just want to put on the table that should be thought of as we continue as far as the board goes. There were 2 or 3 different letters from one of the attorneys, and one of the issues that came out of the letter that I want to highlight that we should be thinking about is the doctrine of exhaustion of administrative remedy applications. In the letter, I'm going to just read a snippet just to tell you why I'm reading it. And it says, this is regarding Kenneth Nash to the members of the board, and this is a letter from Attorney Oshner. And it says in the beginning paragraph, the issue of whether the Zoning Board of Appeals has the authority to undertake a determination of whether the zoning officials' decisions concerning an interpretation of a driveway portion of a newly enacted town regulations. The appellant Nash submits that the law is clear that the doctrine of exhaustion of administrative remedies applies to this situation, and the appeal must be submitted to the ZBA. Now, the reason I'm just highlighting that is that we are talking about a building official's decision on a planned site plan in driveways, not something that has been definitized and finalized, but planned. And I think we should be keeping that in mind. I've been on this board since the late 1980s, and I've never seen or been involved with a decision put before the board relative to a decision, and I'm looking at the new requirements, if I can find them here. I'm looking at the new regulations in section 963A, and the reason I'm mentioning this is occasions for public hearings. The board shall hold a public hearing on all applications for an appeal and or a variance, and may hold a hearing on a certificate of approval of location in accordance with the general statutes. Now, it's always been to my understanding that we would be looking at a variance or an appeal on something that was concrete, not a preliminary plan, or not something that was not finalized in a site plan. And that's what I think I'm hearing. And if I'm wrong, I hope somebody will correct me on this, because we are going to be changing, in my mind, the entire fabric of what the ZBA has done in the past. Okay?
Okay, I
And I
understand.
just want to make sure that we understand that. I
Yeah.
have a problem with that, going with site plans. They should be definitized, and they should be concrete. And if there's an issue with a site plan that has been approved, that's one thing. But we're talking on hypothetical, not approved plans, I think. So I'm going to just turn the chair back over to Ed, and I've expounded on my concerns. And we could just see what the discussion entails. Okay?
Attorney Casey, you have some comments.
Yes, thank you, Mr. Stebbins. And Mr. Manning, very astute observation. The issue of whether a decision by a zoning official is an appealable decision is a matter of a number of court decisions. And you stated it somewhat succinctly. Without quoting chapter and verse, a preliminary decision on a hypothetical situation has been deemed not to be an appealable decision. Whereas something a little more concrete coming from a building official or a zoning official, like a certificate of zoning compliance or a decision that would have a concrete effect on someone's property. So if the ZEO had determined that someone, couldn't put on an addition because it violated, a setback or a coverage, and he said, I can't grant you a certificate of zoning compliance because of this. Well, that's a final concrete decision that impacts someone's use of their property, and that would be something that is appealable. In this case, as you point out, this isn't the final step in the process, as I understand it. There will be a site plan that has to be reviewed and approved by the Planning and Zoning Commission. So this is, this may be one of those preliminary decisions. And I mentioned it, I'll say, because I flagged it as an issue when I was asked to represent this board and I reviewed the materials. And so all the parties have been aware of my concern about it. And I think it's appropriate that they address it in their presentations. And that perhaps when we get done with the presentations and you're deliberating, you could, as a matter of procedure, make a initial determination whether you think it's an appealable decision before you go on to the merits of the case.
Thank you. Okay, so you're recommending that we do continue, as I have stated earlier, the appellant side, the zoning official side, and then John Marr, each presenting their side.
Yes, I think that's appropriate.
Okay,
Way to go.
all right. Then at this time, Attorney Oshner, I don't know if Mr. Nash is with you, but if you'd like to give us the appeal.
Yes, sir. Quite frankly, at the conclusion of the proceeding here, I will be requesting a postponement. Yesterday evening, we received from the person representing the zoning enforcement official a new plan, which is 13 pages long, and I have not had an opportunity to review that. So I will address my primary issues this evening, but at the conclusion of the proceedings, I will be requesting probably a 2-week postponement or continuance to review those matters. I'm getting the site plan from the town planner, and we'll be reviewing it and be prepared to finalize my arguments next week or whenever you're continuing it to. Now, the first order of business would be the issue of taking the appeal. The reason we appealed this was that the zoning official posted in the New Line Day a notice of decision. And that's what I took my cue from is that if there's a decision relative to a zoning matter that the zoning official makes, that may be appealed. And the issue concerning exhaustion of administrative remedies is one which, if I don't appeal it, and I subsequently either take it to court or raise the issue with the Planning and Zoning Commission, the issue of exhaustion of remedies may bar me from taking the appeal to that at that level. Now, just formality, I realize that I'm supposed to identify myself. I'm Ron Ochsner. My address is here in Groton at 10 Horizon Drive, and I'm representing Mr. Nash in this appeal. Now, our primary concern is with respect to the driveway. If you're familiar with the site, it's the extended driveway to Walker Hill Road runs immediately adjacent to Mr. Nash's property, and he is concerned with that. The new site plan, which we just received a small copy of last evening, illustrates that there's that driveway plus another driveway that goes out on Silly School Road. And as a consequence, I have to look at that a little bit further to finalize my decision process. Now, the driveway regulation has 4 requirements. It has a requirement for the number of driveways, exits, and entrances. It has a requirement for distance from adjacent driveways and roadways. It has a requirement concerning, excuse me a second here. It has another requirement concerning street frontage, and the 4th one, which is the distance from adjacent driveways. Now, with respect to each of them, there are certain very specific requirements in getting approvals from Public Works, from other entities other than just a simple distance from the parallel driveways. Driveways are near the corners, and it's our position that there are issues that remain undecided, and quite frankly, the zoning official should, when rendering a decision concerning driveways, advise the party who's seeking the driveway of those decisions. Now, I realize that you can have a driveway across a adjacent property by getting a easement across that property, which the town has done. But our concern, and Mr. Nash's concern, is that that driveway is very close to his property. There's no buffering between the driveway and his property, and his businesses, his residence, and he would prefer that the driveway be located at a different location. I think I've addressed all these issues in my appeal, and I think that a quick reading of each of them will make it clear what the issue is with that particular the problem with the zoning official making that decision, and it should be disapproved on the basis that those things should be considered in making a decision. Now, I will be reviewing a site plan that appears to address some of these issues, and after that review, it may turn out that we're able to resolve some of them, or some of them may not be as much of a problem. But I expect that I will complete that review by the next meeting, and we'll be able to go forward at that point. Now, does anyone have any questions?
Yeah, let me go through the board here. Tom Manning, questions?
What is the status of the site plan that you're reviewing right now, and when will it be finalized?
I can't answer that because I'm not the applicant for that. Mr. Herbst, who I believe is present, may be able to provide.
Well,
information.
I guess here's my question. We can avoid all of this going to the zoning board of appeals for a decision. If it sounds like if your input or your client's input is sought or included, or at least it's passed on so that at least something can be done, if it's possible, to mitigate the concerns that, or the issues that your client has. And it would make sense that we wouldn't be wasting board time. To me, this is valuable time for a lot of, and we're just volunteers. But volunteers, you know, have a life after career paths. And the point is that you should really, there must be a mechanism, rather than going with unfinalized plans. And to me, there should have been something that took place where, I don't know what the reason why that was published in the paper, whether it was asked to be done. But that's just, you know, a decision based on, my opinion, again, a decision based on a preliminary plan. It's not even solid. And that's unacceptable in my mind, having been an engineer for 40 years or whatever, in the federal system. You don't do that. You don't waste people's time. You get the finalized plan. This is the way we're going to do it. And then you present, or maybe there's no mechanism for soliciting the neighbors who are impacted, their comments. Then that's when this type of thing would be legitimate. I mean, if this is all, you know, unfinalized, and it seems like anything could change, and every week there could be changes that would require this whole process to continue on and on. And I don't think that's what it was ever intended. So,
Well,
I've said
again,
my piece, but
Attorney Oshner,
what?
Attorney Oshner, are you there?
Yes, yes, I am.
You indicated that you have some new materials that came in today, and you have not had a chance to review them,
Yes.
which may totally change your case. I
may-
guess in the interest of, well, Mr. Manning said time, but more so having everybody, in other words, if you review that and you come up with some different things, then it's really a waste of Attorney Cody, Attorney Herbst, to go through their presentation when you may have a whole different outlook in 2 weeks. Our next meeting would be the 24th, by the way.
but
So
we have to publicize that, don't we, Ed? If
no,
we continue
not-
it,
my suggestion is that we continue this until the 24th. But I would refer to Attorney Casey if he thought that was a good idea. Attorney Casey?
Yes, sorry, I was just getting,
That's okay.
yeah, I do think there's this issue of appealability. I mean, you have Mr. Reiner on the phone, you have the property owner's attorney. You have basically almost your whole staff and attorneys for everyone involved. I mean, if they could advise the board as to the nature of that site plan, I mean, this appeal, if anything, should be focused on the contents, if it's going to be heard on its merits. It's on the contents of the letter that Mr. Zingelis issued. It's not a review of the entire site plan, which may or may not be finalized. It may have not been submitted to the town for review, approval, anything like that. It could just be a preliminary site plan. I think my understanding from the Attorney Cody is that it was just submitted to respond to one particular issue concerning connection to the, pardon me, to the road system. This isn't the forum to debate the site plan. So if there's significant amount of additional review and approvals that need to be done by the town, I think it goes to the issue that Mr. Manning started with. And, you know, when we come to saving time, you know, you have 4 attorneys on this matter. You know, 2 of them who are being paid by the town. We want to minimize those expenses. If you know, if there's really no relief that this board can give to the applicant at this point, because everything's preliminary.
Yeah.
Again, my purpose for appealing was to avoid the procedure of essentially waiving the right or giving up the right to appeal by virtue of exhaustion of remedies. And I think I provided you a decision where that's established. And my concern is that I'd like to have the matter heard, because it is a decision that may bind me at a later time. And so that's my reason for proceeding in this fashion.
Okay, then, all right. Scott, do you have any questions of Attorney Oshner?
No, when I was going over this, I was perplexed at what we were actually supposed to be doing, because as Tom said, Mr. Manning said in the beginning, it all seemed uncertain, that it was still in a developmental state, which means I couldn't understand why we'd be sitting here doing this, and all these things are usually worked out ahead of time with the actual town officials and biological engineers if they're doing the site plan. I'm uncertain that what would I be taking into consideration? What would I be voting on?
Well, the issues that would have to be resolved is whether or not the zoning regulations are complied with by the applicant in designing the roadway. And if they're not, then the Planning and Zoning Commission can't approve it.
Yeah, but the operative word, sir, is that you keep using it as that conditional preposition, if. We normally, I mean, normally it's not an if something, if not something. It either doesn't comply or it does. And someone, not necessarily you folks, makes an application based on a concrete document or a finished document, or you begin to do something and the zoning official stops you. I mean, there's a number of things that could happen, but as Mr. Manning said, this all seems theoretical.
Well, it's on a plan at this point, and unfortunately, it will be submitted to the Planning and Zoning Commission as is, unless something else happens. So,
Can I speak?
Go ahead.
Can you hear me?
yes.
Okay, this is counsel for Donmar, so I'm just wondering when I can jump in here because I'm chomping at the bit.
Okay.
Well, Attorney Hurst, what I had said in the very beginning, when you get the appellant an opportunity to present their case, then when we give the zoning official their chance, and then you third. Is that okay with you?
Okay.
Okay. All right. Bill Munster,
Smith has a
Bill,
question.
I'm
Ed, I have
sorry.
a question.
Yes, I'm coming to you.
Okay,
Next on the list was Bill Munster.
okay.
Bill Munster, any questions of Attorney Oshner?
Yes, Attorney Oshner, clarify a little more for us. So reading the zoning official's notice of decision, his point is that the driveway to a proposed development does meet the requirement of zoning regs. Would you please list your argument again why it does not meet the zoning regs?
Because it does not provide a requirement that the center of the driveway of the development is the starting point for the measurement to the center line of the adjacent driveway. And if he had used the definition of driveway that's spelled out by the town roadway regulations, it would be from the pavement edge as opposed to the center line. And so our submission is that they've selected a wrong point from which to measure the center line or the distance between the developer's driveway and the adjacent driveway. And that's
Thank you for recapping that. Thanks, Mr. Chairman. No more questions.
Okay, Chuck.
Yeah, following up on that, if I'm looking at the zoning regulations on page 8-18, the diagram there shows the measurements from the center line of one adjacent driveway to the center line of another adjacent driveway as being a minimum of 25 feet. Does the appellant dispute the fact that even in these preliminary plans, it's at least 25 feet?
I can't answer that because I'm not sure what the point of measurement is.
Center line of both driveways.
But the regulation doesn't specify that.
Yes, well, the diagram, according to the regulation, does.
But number one, the regulation doesn't call for that, and that ignores the town ordinance regulation that says the driveway is from the edge of the pavement.
Which regulation are you talking about?
I'm talking about the town roadway ordinance.
Well, but we're in zoning, and the zoning regulation clearly spells out that adjacent driveways, you measure from the center line of both adjacent driveways in the minimum of 25 feet.
That the ordinance, the regulation doesn't specify that. And again, the zoning official doesn't refer to because there is no definition of driveway in the zoning regulations. There is, however, a definition of driveway in the town roadway ordinance. And it's our position that using that will affect the position from which that regulation that distance should be measured.
So even if we assume it in the best in your favor, is it less than 25 feet?
I can't answer that. I don't have a method of actually making that measurement.
Well, that's your whole case, and if you're going to convince me of anything, you got to tell me what you're maintaining.
Well, I think there is other issues that relate to the design of the driveway.
And what would they be?
Pardon me?
And what would they be?
Well, that were the other provisions of the regulation.
Which regulation? The zoning regulations?
Zoning regulation, yes. There are 4 parts to it, and there are issues with respect to each of them.
So tell me exactly which regulation you're talking about. Cite me the number.
Well, it's 8.2-12B.
Okay.
And it has 4 subsections.
Yep. So tell me what you're talking about.
Okay. Well, one is the point 1 is the driveway entrances, the design of those, and why they're supposed to follow the standards of the Groton road and drainage standards. It specifies that in the regulation.
Okay.
And there's no reference at all in that decision that those have been followed. Second one would be the 8.2-12B2, which is street frontage. And it provides that where there's available public right-of-way, which there is by Sealy School Road, that that Sealy Road should be utilized as the right-of-way and the frontage that is on the lot. This it hasn't been done because they've decided to go out across city property, for which the town has acquired an easement, but it ignores the driveway across that is already there. That is the roadway that goes into the property. Is Sealy School Road, and that is at the current plans supposed to be closed, and the only access route is through that easement property. The third one.
But let me interrupt you there. If I read the regulation, it requires the Planning and Zoning Commission to approve it.
That's right.
So until they've taken action, we've got nothing to decide about.
Well, that's right, but it again is a matter which the zoning enforcement official should advise the applicant of what the requirements are. And it provides that, the third one would be zoning regulation 8.2.12B3, which is limiting curb cuts. And by putting a new road out to the Walker Hill Road, instead of reducing the number of curb cuts, they will be increasing the curb cuts because there will be curb cuts on Sealy School Road and Walker Hill Road. So
Yeah, but that's not mandatory. It's strongly encouraged. It's not mandatory.
Yeah, well, but again, it would be up to the commission to approve it.
Right, and then you could appeal to us if the commission came down with a decision which is adverse to your client, correct?
Mhm. Yes, well, it depends on how the decision was made, but if it's.
And wouldn't that then give you an opportunity to exhaust your administrative remedies at that point after the Planning and Zoning Commission has acted?
I think because it's been characterized as a decision, I don't have any choice in the matter other than to file an appeal. And that's the way I read the cases. And they are pretty strict in terms of applying that rule, because if you fail to exhaust an administrative remedy when you should, you will be subject to having your case dismissed.
At this
But that
time,
would assume that you're going to appeal this decision that you want from us now directly to the court without even a decision from the Planning and Zoning Commission, correct?
See,
Yes.
this is the danger of having an appeal of something that is fluid and not finalized.
I
have
agree,
a real
yes.
issue with this,
Yes.
real issue. I think
So
maybe
that-
we ought to stand back and just not, as a board, not hear the case
Right.
and say, come back when there's something firm.
Mhm.
And in the meantime, I would suggest that your client should be talking to the developer to elucidate what he would like to see, and hopefully there would be some good neighborly blood that would allow for some of his comments to be taken in.
Well, we can certainly take that on board, and I'll certainly discuss with the client the prospect of doing that. But we'll see how that goes. But I can.
Can I ask a question, Ed?
yeah, go ahead, Scott.
It appears Attorney Mosner is there's two distinct issues here. He's saying he's here tonight because he's concerned that a potential appeal would not be allowed because something was published or stated. Is that true, sir?
Well, yes, that's true. I don't want to be in a situation where
Okay,
the matter is taken up. I've not filed an appeal in front of the ZBA of a decision, and the defense of exhaustion of remedies it could be thrown back at me.
okay, I understand that. So we're really here as a consequence of a concern about an administrative action and not about the actual appeal of the zoning regulation.
That's right.
Well, Ed, why are we
Yeah.
here?
That's a good question. It may come back about us in the future, but I think I have mixed emotions. I agree with you and Tom, but I think it's only fair that Attorney Cody and Peter Zinglis and then Attorney Herbst give their side. Then we can make some sort of decision. I know it's taking a little more time, but I think we should be fair to all parties. And I think Attorney Casey sort of alluded that we probably should. Am I correct, Attorney Casey?
So, yeah, before I would just, because even the decision not to make a decision, if you decide it's not an appealable issue that's properly before your board, that's a decision that could be appealed to court as well. So I would recommend that you hear from the
rest of the folks out there, yeah.
officer, his attorney,
Sure.
so you can have evidence in the record of if the simple answer to a question like can Donmar build this driveway based solely on the letter from Mr. Zinglis? If the answer to that is no, they have to go get A, B, and C approvals from the Planning and Zoning Commission. That supports your decision. If you go that way, that would support a decision that this wasn't an appealable issue. So I think it's just good to get that evidence just in the record and to clear up a couple other things. And
Hey.
while I have the floor, I'll just make a point about the notice, and Attorney Herbst can talk about this, but the notice that was published in the paper, that caught my eye as well, because publication of a zoning enforcement officer's decision under the statute, it's 8.3F. That talks about no building permit or certificate of occupancy without the ZEO's certification and writing that that the building use or structure conforms with the zoning regulations. And then they've added this part in order to make this appeal period very clear. They added the part where the ZEO can tell the applicant that you can publish decision of this in the paper, which starts the zoning, the appeal period, so that people aren't subject to like a very extra long appeal period. You get a decision, you get your certificate of zoning compliance in January, but you don't start, you get your contractor lined up, you pay money, and then you start digging in October, and that's when the neighbors find out that you got this certificate of of zoning approval, and then they appeal, and you're kind of out of luck there. So they created this process where you can go and appeal and publish notice of your certificate, so it starts the clock and ends the appeal period. But those are for certificates of zoning compliance. Those are for something that lets you do something as the applicant, and it's very specific in there. It's supposed to say, the notice has to contain the description of the building, the location of the building, the identity of the applicant, and a statement that the aggrieved person may appeal to the zoning board in accordance with section 8-7 of the regulations. Well, the notice here is sort of, it doesn't do all that. And I think that's because, in my opinion, it wasn't one of those final decisions. So it couldn't contain all that information. And it didn't even say that someone could appeal the decision to the zoning board. It just said that there was, it's in the record. It simply says, I have to enlarge it here. that the town of Groton manager of inspector services acting as the town zoning official determined that a driveway to a proposed development at 55 Steely School Drive meets the requirements of zoning regulation section 8.2-12 .a4, distance to intersection of other properties' driveways. The file and map are available for public inspection during the normal business hours in the Office of Planning. So all it says is that it determined the driveway meets the regulations. Now, I understand Attorney Oshner's concern, but that doesn't, it doesn't give Donmar the ability to build that driveway now. And I don't think the zoning enforcement officer can bind the Planning and Zoning Commission, who has ultimate authority on interpretation of its regulations. So this can go to a public hearing for the site plan, whatever. I don't even know what process needs to be followed, but the Planning and Zoning Commission could say, no, we interpret that differently. It doesn't matter what Mr. Zingler said. So it is preliminary, in my opinion. But I'll stop now and I'll let you hear from others because I think it's important.
Oh, okay, so speaking of Mrs. Zingler, he and Attorney Cody, if you'd like to take over, let us know what your side of the story is.
Okay, can you all hear me?
Yes, we can.
All right, good evening. I think it's important. I listening to everything. I'm a little confused by it. The only issue before you is a very simple one, and it was the only issue that was asked of Mr. Zvinglis. And before he tells his story, I just want to sort of lay out the parameters. Mr. Zvinglis was asked only to interpret, based upon a plan he was presented, a sketch, a preliminary plan, section 8.2-12B4. He was not asked to interpret subsections 1, 2, or 3, which Mr. Oshner is trying to get you to consider. Though sections 1, 2, and 3 involve site plan discretion, which you don't have any authority over. But more fundamentally, because Mr. Zvinglis did not rule or issue an opinion based on 1, 2, or 3, there's no appeal that can lie because he didn't issue a decision on them. He only ruled on number 4. And that issue, I think it was Commissioner Smith, noticed very clearly that, the regulations have a diagram. And I think it's being suggested to you that the diagram is somehow outside of the 4 corners of the regulation, and that you're not supposed to consider the diagram as elucidating the text of the regulation, but instead you're supposed to read the regulation as though it's vague, and you can't use the diagram to interpret it. I think, the issue is really academic from our standpoint, from Mr. Zvinglis' standpoint. I'm sure he was curious as to why he was even asked the question. But it's clear that the plan that he was presented, he'll lay it out in more detail, shows a driveway on the Donmar side of the property. And this one here, it's part of Mr. Oshner's report. The driveway itself here is 50 feet wide, right, Pete?
Yeah.
50 feet wide. So starting from the center line over to the property line, you're already 25 feet, not to the property line, but to the edge of the pavement, you're 25 feet. Then you're at the property line, you're nearly 30 feet. So the issue was academic. And that's really the only question before you, if you can get past the issue that Commissioner Manning and John Casey has made as to whether this is really a final decision for purposes. But more to the point, the issues of 1, 2, and 3 have nothing to do. You can't reach them because he didn't decide it. Now, there's been this question about the plan that we submitted, the newer site plan. That was presented because, it's always, what lawyers always do is they say, on the alternative, you decide to reach these other issues, here's some evidence against it. There was an argument that being made by Attorney Oshner that this Sealy Drive is going to be discontinued, and that therefore there would be a second curb cut once the discontinuance happens. So I looked for a plan. I asked Deb Jones, I said, is there a recent plan is there any plan for discontinuing this drive? And she said, no. And she sent me, this is the updated plan. So I figured I'd present that to you only for the purpose of demonstrating that there's no plan to discontinue the drive. But the issue of the 2 curb cuts, which you've noticed is totally discretionary, it's not mandatory. But that issue was never decided by Mr. Zvinklis. So it's not before you properly, because without a decision by Mrs. Zvinklis on that issue, no appeal can lie. So I'll just let Peter testify, and Ms. Roshner may want to ask him some questions.
Okay, so I was just going to give you a few of the documents to look at when we were going through. So November 11th, I was requested with a letter. I don't know if I have the ability to share screen right now. Bear with me 1 second on this. This is the trick of it all. Are you able to see that letter?
Yep.
Good.
Okay, so this was the letter that Attorney Herbst requested. And he was basically, it was trying to figure out how to move forward with his site plan to present to the Planning and Zoning Commission. So basically, he was trying to make sure that they were interpreting section 8.212B4 correctly. And so basically, he was stating in there, it is our position that the proposed plan fully comports with the requirements of section 812B4 of the regulations. We respectfully request that your department confirm that our interpretation as articulated here in above, as measured against the enclosed driveway plan as prepared, is in full compliance with the regulations. That was the only thing I was looking at. And then if I go to, this was the picture that's in our regs depicting the 25-foot minimum separation between the center line to a center line of a driveway. This is what we follow in the regulations. And then this was the submittal showing the 50-foot strip for the access for the driveway, which would be 25 to the property line, and it's showing 62 feet from center line of this driveway to the center line of this driveway. It's pretty cut and dry. What I was determining was the 25-foot measurement, center point to center point of 2 driveways are in compliance with the regulations. And that's all that was all in my letter specified back to Attorney Herbst. So that's kind of where we're at.
Okay. Doug, do you have any questions for Peter?
One question, yeah. The thing that struck me on Mr. Nash's property is, even if he didn't have parking in his entire front yard and he just had a driveway that was centered on his garage area, it's still out more than 25 feet from the center line of the proposed driveway from Sealy School Project.
Correct.
So it may not be 62 feet, but it would be probably 50 feet at least. Is that fair analysis?
Yeah, and that's why that's why in my letter I was discussing sizes of driveways and everything else, because that could come into consideration. But I'm like, you're already at 25 feet getting to the property line. So no matter where you put the center line of that driveway, you could have right up against the property line. You'd have more than 25-foot center point to center point.
Okay.
Okay.
That it, Doug?
Yep.
Okay, Bill Munster? Any questions, Bill?
No, I've got no more questions. Thank you.
Okay, Scott?
No, thank, I'm good.
Okay, Tom Manning?
Not at this time. I've said too much.
Okay, Attorney Herbst, it's your turn. You out there?
He fell asleep.
I'm here.
Sorry?
I'm just unmuting. I apologize.
Okay, no problem.
I wanted to mute it so you didn't get any background. Mr. Chairman, I want to thank you, and I want to thank the members of the board. For the record, my name is Timothy Herbst. I'm an attorney with primary offices in Orange, Connecticut. I am the attorney for Donmar Residential LLC. Its president, Mario DeGioia, and its officers, Michael and Anthony DeGioia. I believe Anthony is on the call this evening listening. I intend to keep my comments brief. I don't intend to reiterate what the other attorneys have said tonight, but I would like to specifically address 3 areas that I need to get on the record in the event that an appeal is taken. And my comments are going to focus on 3 very specific areas. That is ripeness, venue, and precedent. And let me just start with ripeness. For a claim to be ripe, has to be right when the facts of the case have matured into an existing substantial controversy warranting the intervention of an administrative agency. I don't believe it's right based upon much of what's been said tonight, because we don't have a decision from the Planning and Zoning Commission on a pending application. I absolutely agree with the doctrine of exhaustion of administrative remedies predicated upon the right administrative agency being the point of contact to bring an appeal or to raise issues before a regulatory body, before an approval is granted. So currently, we are undergoing staff review of this site plan application that will be heard by the Planning and Zoning Commission. If Attorney Oshner has concerns with how the regulations have been interpreted, then he will have every right, when I go before the Planning and Zoning Commission on behalf of Don Mar Residential and enter certain items into the record, like traffic reports, like architectural plans, like testimony from our experts, he will equally have the right to enter into the record anything that he deems appropriate, whether it be traffic reports, expert testimony from private planning consultants supporting the propositions that he's raised with respect to the interpretation that Mr. Zvingilis previously made. He'll have every right to do that. The Planning and Zoning Commission will then have the right to assess all the evidence that's been put in the record, and they're going to make a decision. If I don't like the decision, I'm going to take an appeal to the Superior Court. Attorney Oshner does not like the decision. He's going to take an appeal to the Superior Court. So this issue is not ripe for this board's consideration, A. B, I don't even believe this is the appropriate venue to be raising these issues. That venue is the Planning and Zoning Commission. And C, and finally, I think that what is going on tonight, if this were to be continued or go forward, is going to establish a very dangerous precedent for the town for this reason. Mr. Zvingilis, I'm sorry, did I pronounce that correctly? I apologize.
Yeah, you're close.
Close. And my law partner is Greek too, so I apologize. So, Mr. Zvingilis is a public official in your planning department. And you have public officials, dedicated town employees that every day are asked to render opinions on the regulations that are advisory in nature. Just because he issues an opinion doesn't mean that the Planning and Zoning Commission is necessarily going to agree with it. But if we start allowing individuals, businesses, anyone that claims standing, if you start allowing people to appeal staff's opinions on certain things that have yet to be adjudicated, I think we're establishing a dangerous precedent where you're going to have staff that's going to be gun shy to interact and interface with the public on legitimate questions that have been raised, asking for some professional acumen to interpret certain provisions of your regulations. Further, I think what we're establishing a very dangerous precedent in the sense that we're almost, by doing this, and I'm not saying this isn't directed towards the board, but more so the whole process that's been undertaken tonight, we're almost weaponizing one town board against another. So if you were to proceed with rendering a decision on this either way, this then allows Attorney Oshner to go before the Planning and Zoning Commission as the application is pending to say, well, the ZBA has continued this because we need additional information. We want, ZBA to fully vet this. That's not the function of the ZBA. The ZBA is not to second guess the Planning and Zoning Commission. The ZBA's authority is statutorily prescribed and very clear. It is to hear appeals of actual decisions, and it is to vary the regulations. It is not to second guess or opine upon what is an advisory interpretation. That's not the function of the ZBA. And my concern is that a lot of items were included in the February 4th, 2021 letter from Attorney Oshner that really aren't even related to the November 2020 2020 letter issued by Peter. And I am concerned about all of this going into the public stratosphere when the Planning and Zoning Commission has not yet formally met to consider this application. And I am concerned that a lot of these allegations that are being raised before the ZBA could potentially contaminate the process of review that will be undertaken by the P&Z. And for those reasons, I do not believe this should at all be continued. I believe that you should summarily say, this is not ripe, this isn't the appropriate venue, we don't even believe we need to act on this. If Attorney Oshner wants to take an appeal, we'll go have it out in Superior Court. But the real venue for where this application is to be adjudicated is before the Planning and Zoning Commission. That's where we both have the opportunity to exercise our respective administrative remedies in introducing evidence into the record. And it is the Planning and Zoning Commission that is to render a decision on this application, either up or down. And then we will exhaust our remedies in Superior Court if we have to. But this is not appropriate for the ZBA in any way, shape, or form tonight. Thank you.
Thank you, Attorney Herbst. Any questions of Attorney Herbst? Doug?
Nope.
Okay, Bill Buncer? Bill?
Sorry, I had to unmute myself there. No, I think I'll pass. Thank you.
Okay, Scott? Any questions of
Me?
Attorney Herbst? Yeah.
No.
Oh, okay. Tom Manning?
No, I think Attorney Herbst did a great job in
Yeah.
articulating what I had thought right at the beginning, that we were setting a dangerous precedent and we had never done this before on preliminary stuff. I think his words, I would agree 100% with.
Okay. Is there any written comments on the file? Thomas Henry?
There's nothing that you haven't already seen or been presented with.
Okay. Is there anybody out there that you see that wants to add any comments?
There are 6 or 7 attendees. If any of the attendees could raise their hand if they'd like to speak. I see Timothy, Jessica Del Rosario, Ken Nash, Mario DeGioia, Michael DeGioia, and Patty Judson. And there's a phone number beginning with 203. If any of these people would like to speak, please raise your hand. I'm not seeing any.
Okay. All right. So at this point, if nobody has anything else to say, we'll call the public hearing to a close at 8:03. Does anybody have anything else to say?
I would just ask, I would say if you want to give Mr. Oshner a chance to rebut.
That's what I just sort of asked. Does anybody else have anything else to say?
I thought Tom was just going to the public and not the.
No, anybody. About Attorney Oshner, do you have anything to say?
The only comment that I would have is that it may be more appropriate when a notice is published to represent that it's a notice, an opinion as opposed to a decision. Because a decision means something in law, and it means that the official has made the decision that it complies or doesn't comply. And if it's just simply a notice of advisory opinion, that would be the appropriate way to characterize it and wouldn't trigger any appeals.
Okay, thank you. Anybody else? One last time. Okay, 8:04. We're calling the public hearing to a close. Thank you all very much. Okay, so board members, Doug Smith, your thoughts?
I agree with the attorney for Donmar. I don't think the controversy is ripe at all for us. I don't think, I think it's outside of our jurisdiction and I think it's not appealable.
Okay, Bill Munzer?
Yeah, I want to thank everyone for trying to drive this to a conclusion. I share that opinion. I'd like to see some way that we This is not yay or nay. We want to just refuse to make a decision on it is my direction. The
Thank you.
sense that- Yep.
Go ahead.
No,
ahead.
that's all. Thank you, Mr. Chairman.
Okay. Scott?
What Bill said. I'm saying exactly what he said and what Mr. Smith said, Doug Smith, and there's nothing to make any decision about. So I think we need to make that clear.
Tom Manning?
I think we ought to formulate some type of motion that we say something to the effect that a decision is inappropriate at this point
Or
on
the
preliminary information.
is there a consensus on that?
Yeah.
Yep. Okay. Attorney Casey, do you have a suggestion of how we can word this? The general feeling is that we don't want to.
I'm scribbling away.
Okay, thank you. Fast and furious.
Um, So what I've done is someone could move that the subject of the appeal was a preliminary advisory opinion and is not a decision appealable to the zoning board of appeals. And as such, the board takes no action. Well, you're not really taking no action. You're finding that it's not an appealable decision.
Yeah.
So move that the subject of the appeal was a preliminary advisory opinion and is not a decision, advisory opinion, and is not a decision that is within the jurisdiction of the zoning board.
I'll move that.
Okay, is there a second?
Me?
Okay, Scott, thank you. Any discussion further? All those in favor, signify by saying aye.
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 Any opposition? Any abstentions? That motion is passed. Tom Zanderini, I'm sure you have that all written down.
We have it.
I can state it again. So it's move that the subject of the appeal was a preliminary advisory opinion and is not a decision that is within the jurisdiction of the zoning board of appeals.
That's it.
Maybe you could email it to him, John?
I'll email it too, yes.
Okay, fine. All right. Okay, so we're moving right along.
Thank you.
Thank you all.
Thank you.
Thank you.
Good evening.
Thank you, guys.
Good.
Thank you.
Tom Zanderini, any correspondence?
I have one thing to share with you. There's a class coming up. If you're interested in taking it, let me get it here.
Is that the all-day one that used to be up at Weston?
Right here, the Connecticut Land Use Law.
Yeah.
Right.
It's a online class now. It used to be held at Wesleyan University,
Yep.
but it's a Zoom meeting. So it's a good refresher for board members, commissioners, for the latest land use law. So if you want to do that, please let me know as soon as possible. The deadline to sign up is Friday.
Okay.
I believe Deb sent her an email. Okay. All right. Any other correspondence, Tom?
There's no other correspondence.
Okay. Approval of minutes. Now, maybe I missed something, but I didn't see minutes.
I
They
didn't see
sent?
them either. No, I didn't see them
Okay.
either. Yeah.
Me either.
Okay, so why don't we push that off until our next meeting?
Sounds like a plan.
Yeah, there was so much paperwork. Okay,
Yeah,
boy,
there was a
I
lot.
better put it all together. Actually, she sent out the notice with the packet on Sunday. I was surprised to get the email on Sunday. Working hard from home. I'm
Yeah,
sure.
she's been pulling a lot of shifts because Deb's carrying quite a load with Kara being gone. So she's
I'm
really,
sure.
really
I'm sure.
has like 300 pounds on her back right now. So
Oh, she's a trooper. Old
yes,
business.
she is. Nothing old.
Okay, how about new?
Or the only thing old is still the pending applications. 46 Essex Street will be at the next hearing in February on
Okay.
the 24th.
Yeah.
And there's still, the Casino Road still has some questions that I'm getting from Greg Fettis, just some clearer answers on his appeal. He's like 8 variance requests, so I'm just getting more details from him.
Okay, great. Report of staff.
Nope, that's it.
Okay, and the quarterly newsletter from the zoning, that was in your package.
Right.
Yep.
Okay, so anything else for the good of the order? Hearing none, I'll accept the motion to adjourn.
So moved.
Is there a
Seconded.
Second.
Okay, all in favor? Aye.
Aye.
Aye. All right, we're through. Thank you all very much.
Thank you.
Thank
Good
you,
night,
Tom.
everyone.
Good night.
Hasta la
Good
vista.
night.
Guten
Take care.
Abend.